welcome to the fifth episode of Consumer Credit Matters podcast. I'm your host, William Black, and I'm going to start this podcast out a little differently than some of my other podcasts with a short preamble just to set the table a little bit. In this episode, I'm joined by my colleague, my friend, and legal expert, Steve Macy, to discuss a decision from the Third Circuit Court of Appeals just this past March. The case involved is the CFPB versus the NCSLT, and we'll tell you what those acronyms stand for and go into the weeds a bit. But this is a very important case for, in my opinion, for consumer credit and financing consumer credit. And again, I just wanted to mention a couple of things off the top to set the table, especially for those of you who may not be that familiar with either securitization or what I think are some kind of legal foundations on which securitization is built. So just two things. One, securitization itself. We know that consumer spending generates approximately 2/3 of the growth, the GDP growth for this country. Very important. A lot of that is done on credit, and a lot of that credit is financed through the securitization markets in the capital markets. Securitization has been around for decades. It is, suffice it to say, an important part of financing kind of the real economy and consumer credit, even more specifically. That's point number one. Point number two is that one of the tenets of securitization is that the issuance vehicle, that is the special purpose vehicle, legal vehicle that is used to issue the securities, has up until this case been assumed to be protected from contracted third-party liability. And that is what has now been called into question by virtue of the decision taken on March 19th of this year. Again, Steve and I will go into the weeds on this topic and its implications. I really hope you listen through the whole thing and do comment. If you have any comments, leave some comments in whatever platform you're listening to, Spotify or YouTube or LinkedIn, and enjoy. Thank you. Steve Macy, welcome.
Well, Black, how are you doing?
Good. How are you doing?
Pretty well. You are looking you're looking svelte and smart today.
As are you, and well read, I have to say, by virtue of your background.
The books in the background, yeah,
that's right. Oh, how many people are going to zoom in now on all of your library of books and judge you now? I hope those are all, legit legal books, legal scholar, being the legal scholar that you are.
Philosophy books, but I'm not sure.
That's pretty impressive. We'll see if we have time to jam in some philosophy in this conversation. But thank you for joining the podcast. And based on our prior conversations, I've been really looking forward to having this conversation with you and have a conversation with someone else on this topic. And so, just to kind of tee it off a little bit, this podcast is going to be focused on a legal topic. So do stay tuned. I mean, this is. To be specific, it's a specific court case in the Third Circuit Court of Appeals, a decision that was taken on March 19th of this year in the case called the CFPB versus the NCSLT, the National Collegiate Student Loan Trust, or trusts in this case, versus the Consumer Financial Protection Bureau. And the decision was, at least for me, I think, Steve, it's fair to say also for you and for other folks who follow the securitization news profession, was a surprise, if not a shock, in that it essentially eroded or weakened. I'm trying to be nice here, maybe. Some foundational tenets of securitization, insofar as it now allows for a path to the what has been held as kind of sacred trust and trust assets. If, say, a third party contracted third party servicer is found liable, which is one of the allegations in this case, that there is a legal path to pursue all the way to the trust and the trust assets. That is something that has been very well legally protected against up until now. So we're going to talk a lot about that and its implications for certainly consumer-oriented securitizations, but maybe securitizations more broadly, and go into that in quite a bit of detail. So, Steve, maybe just to start off, why don't you give us a little bit of your background, and kind of how you got to where you are today.
Sure. Well, I started out as a securities lawyer in New York City doing structured finance. I did that at several law firms, and then I joined you and others at Moody's, doing both legal and analytical work on structured deals. After that, during the credit crisis, another Moody's guy and I, Jay Eisberg, started a fund to take advantage of the fact that people simply did not understand what was good structured finance and what was bad. Everything seemed to be lumped together in the bad category. And that went very well. So we're now on our second fund. I've also, along the way, done a lot of artificial intelligence work, but that's not especially relevant, I suppose.
And some apparently some work in philosophy as well.
Well, that was when I was young and idealistic. Yeah.
Okay. Well, like I said, we'll see if we can bring some of that to bear here in this conversation. And I remember, when you and I were working together back at Moody's. Now, this was almost, as we were talking, almost 30 years ago. Not quite, but almost. And you brought your legal background to that role and were certainly a mentor to me among many others at that time. And back in those days, the legal aspects of a securitization, and certainly in consumer finance, were not as well paved as they are today. So there was a lot of focus, a lot of scrutiny on a relative basis. There's still very important tenets, don't get me wrong. We still get the same opinions, the same set of opinions to rely upon to some degree in securitizations today that we got back then. But there was just a lot, it seems in my recollection, a lot more hyper focus on every word, every punctuation mark back in those days versus today, where things have become much more boilerplate, I think. And of course, the industry has prospered because of the legal tenets that are involved. And here I'm referring to like perfection and true sale and non-consolidation and tax opinions, all these things that are part and parcel of every transaction, and sometimes get overlooked as important parts because they are so routine now, but they certainly are exceptionally important foundational aspects of any securitization. So why don't we start off with, Steve, if you don't mind, just giving us kind of a broad overview of the case in question here, the CFPB versus NTIA SLT, and just outlining the broad contours of that court case, if you don't mind.
Well, there are 15 Delaware statutory trusts. Each trust is an owner of a pool of student loans. Against those student loans, each trust issued bonds. Okay, so this is a standard function of a structure in a securitization. You have a bankruptcy remote entity that owns some assets and issues some securities against them. The idea being to make it the case that capital markets participants can participate in a market that they did not previously participate in. So there is here also a standard servicing arrangement because the issuers, the trusts, have no employees, they have no operations, they have no anything. So there's no way for them to deal with consumers on a one-to-one basis. The standard way of handling that is to have a servicer contracted to do that for the issuers. Here, as elsewhere, there are also lower down servicers, especially when, say, a loan goes into default. Typically, that loan then gets shunted off to somebody else who is an expert in dealing with that sort of thing, and those are called subservicers or special servicers or whatever. In this case, the two subservicers filed a bunch of collections lawsuits over about a 4-year period. And the CFPB thought that some of their practices were not so very good, and so they and so they investigated and they sued, saying this is consumer fraud. Okay, it's really not that much. I think there are about 800,000 loans in total, about 12 billion in outstanding aggregate principal amount, and all that the CFPB could allege was less than $1 million a year nationwide. So it's not very much, but okay, they're doing their thing. They got some money, $2.5 million, I think, out of one of the servicers, and everything's fine, no problem. Then they decided they are going to sue the issuers themselves, the owners of the loans. Okay. Well, in order for them to do that, under the statute, the issuers have to be what are called covered persons. Okay, that's the way in which the CFPB gets jurisdiction over anybody. It has jurisdiction over covered persons, right? Well, a covered person is just defined as anybody who engages in offering or providing a consumer financial product or service. Okay, so the question here, there are many questions in this litigation, but the question that we're concerned about is that foundational question, whether or not the CFPB has jurisdiction over these people, over these trusts. So the case has gone, it's a tortuous process, but to make it short, the district court said, yes, CFPB, you do have jurisdiction over these trusts, and the Third Circuit recently agreed, and that's what we are going to talk about today.
And I mean, there's a few things here I want to round out, especially for people who aren't necessarily focused on the legal end of these transactions. One is that, first of all, this decision from the Third Circuit itself, let's just stop there. This is the second highest court in the land. This is a very, big deal decision that can only be appealed. I guess they can request that it be reviewed by the Supreme Court. Okay, that's, you can request, but you cannot demand that Supreme Court sees any case, I suppose. And I think we're going to talk maybe about another bit of recourse they may have in terms of an en banc review that they have requested. We'll talk more about that in a moment, I'm sure. But my point is that this is like I said, the second highest court in the land. So there aren't any guaranteed paths beyond this decision at this point, right? So that's one point to make. The other thing, the other point that I wanted to make was this is hinging, just getting back to the legal fundamental point that you articulated. It's getting back to the definition of a covered person, quote unquote, covered person, which is a concept that came about with the CFPA, the Consumer Financial Protection Act, which was brought into existence. If it wasn't, was it the Dodd-Frank or post Great Financial Crisis slew
Yeah.
of? I think it was Dodd-Frank.
Yes. In 2010.
Legislation.
Yes.
Yeah. Sorry. Go ahead.
In 2010. Yes.
Right, in 2010. So this concept of a covered person that was decided that was being litigated came about by virtue of the CFPA, and that's kind of at the center of the court's focus and decision making, and ultimately they decided that the trust was indeed a covered person. Maybe you can talk a little bit about that in more detail. Like, what is it that the court saw, or what is it the CFPB articulated and the court agreed with, that makes the trust a covered person in this case? Because as you said earlier, the trust is by construction a brain dead entity that has no operating function. It is not an operating company. It just simply holds the assets, right? So how can it be in the business of, how can it be considered a covered person by virtue of this legal argument?
Well, that's a very good question, and I personally would say that it has not been established by the Third Circuit's reasoning or by the district court's reasoning. Essentially, though, the court looked at the fact that the trusts hired somebody to do these servicing activities, and then said, well, the term engage is a very broad one. It means they look it up in the dictionary, and they say, oh, you see, it means to be involved in, to be employed in, and so on and so on. Well, certainly these people are somehow or other involved in consumer finance, so they must be, therefore, engaged in the business of offering or providing a consumer financial product or service. That is about the level of the argument that both the district court and the Third Circuit went into. It was a fairly shocking, shockingly superficial analysis, given the potential implications of the whole thing.
Right. So by mere fact of, I don't even know. I mean, yes, it is a very thin line. Just because they were the trust, just because they, I don't know, have consumer finance. I'm trying to get the connection myself. I mean, just to be fair, I guess, to maybe, if that's the right word, to the CFPB's position here, they are mandated to look after consumers. They are going to use, as they should, any powers that they have to pursue, I guess, penalties or enforce regulations or laws that are already on the book. This is part of their mandate, and they should do that with the full force of their authority. So they saw here a path. They are pursuing that path with, again, I'll use allegations against the servicers for malfeasance, and they said, well, look, the trust, even though you don't actually have any employees who service the assets, by virtue of the fact that you are connected by this securitization structure, which is again, no operational functional responsibility, that just because you are a part of this securitization structure, you are therefore in the business of consumer finance, and therefore a covered person. That's the logic.
Right. In fact, the district court put it just baldly. It said, the question is whether you can be and whether you are engaged in the business of X if you employ someone to do X for you. And it answered yes. And the Third Circuit agreed. Now, just
sorry. Does that mean that because because the trust is hiring, you mean like they choose who the third party servicer is, that because of course you have to do that, right? Somebody's choosing who all these third parties are to the securitization legal structure, and by virtue of making that decision, that therefore puts them in the business of being in consumer finance. Is that
well,
what
I suppose
the
something
logic
like
is?
that. Although, of course, since the trust has no employees or operations, it does not make any such decisions.
Right.
Right? Typically, the arrangements are all set up at the time the deal is done, and they may change going forward. But in this case, there's an administrator in the deal, and the administrator was an operating company and was responsible for selecting these sub-servicers. The servicer was on board and has been the same the whole time, but the actual hiring of these sub-servicers, the decision that they are the right people to handle the thing and so on, was not done by the trust itself, because the trust does nothing. It is a bare legal entity. It exists in name only. And so the question just was, can we say that a bare legal owner is responsible for the things that are done downstream by people who are employed by it to do one thing or another? Well, you might ask yourself, wait a second, I own a house and I employ an electrician I hire an electrician to redo the wiring in my house. Well, I have hired somebody to perform a service for me. Does that mean, therefore, that I am engaged in the business of offering electrical services? No, it does not. The electrician is engaged in that business, but I am not. So when you begin to look at these ideas, they just start breaking down very, very quickly, and they break down again when because the expression "engaged in X" is, as the Supreme Court has said, a term of art. Yeah, it's not just a collection of words. It's a collection of words that has a very distinct and heavily litigated meaning. So, for example, the tax code asks whether you are engaged in a trade or business. Okay, and there are many other uses of that expression. So you can't just look up the words in a dictionary and then facilely conclude that yes, you're involved somehow or other in this, however indirectly. Therefore, you are engaged in the business of whatever. It's a surprising decision, and maybe the most surprising is that it pretended to follow a recent Supreme Court decision on a similar kind of thing. It was a different statutory regime, but the court had to ask whether somebody was engaged in the business of interstate commerce, as it happened. And the court did, in fact, look up the words in the dictionary, but what they said was, no, it's not just involved in. You have to be directly involved in. Okay. Well, here, if these issuers are involved in the business, they are certainly only indirectly involved. So by that recent Supreme Court case, you would think the Third Circuit ought to have said, no, they're not engaged in the business of consumer finance,
Right.
So it's a difficult decision really to take seriously, but it's out there and it's good law for so long as until it's overturned.
And a couple of things I want to again kind of just establish for the non-legal experts. One is the Third Circuit's jurisdiction. Maybe you can talk a little bit about that. I know that's narrow. It only covers a few states, but it includes some important states. And not only that, but obviously it can be used as precedent. Maybe you could talk a little bit about that aspect of the decision.
Well, the Third Circuit covers the states of Pennsylvania, New Jersey, and Delaware. Delaware being a very important one because many issuers are somehow or other incorporated or founded under Delaware law. But the entire United States is broken up into circuits, federal circuits, and in each of them there are lower court judges, district courts. Then there is above them a court of appeals, circuit court, and then above them is the United States Supreme Court. So those are the states that are involved here, and it's and technically this is only good law with respect to those three states and the activities of anybody in those three states. But it remains to be seen how other circuits will understand the thing.
And as you say, so many securitization trusts the rule of law is Delaware, right? So that in and of itself means this is very broad sweeping, has very broad sweeping implications. The other thing I wanted to underscore is, it's easy to forget again, is that, since securitization's inceptions many, many decades ago, there has been the concept of this, legal isolation. I refer to it as a kind of a moat surrounding the trust and the trust assets that is both deep and wide, protecting it from any number of call them legal attacks, separating the collateral that is being securitized, that backs the securities that are being issued into the capital markets, from things like the bankruptcy of the originator, or, more to the point here, the liabilities of the contracted third-party servicers. This has been, kind of day one tenet of securitization. And frankly, I don't know that securitization can work without that. I guess we're going to find out, just how damaging this decision could be. And I don't want to make too much out of it at this early stage, and how it's going to be, how it's going to manifest itself in the world. We're going to talk a lot about the implications of this decision, or what the implications might be, and actually, frankly, what they already have been, right? Because there have been some knock-on effects of this decision, even in these early months since the March 19th decision. So I just wanted to underscore that point, that this is now building a bit of a bridge over that moat, right? A legal bridge over that moat from, that up until now has protected the assets, the very assets that are backing the securities that are issued out of the capital markets. And by the way, I'll also add this point, in terms of consumer finance, I mean, two-thirds of our country's GDP is powered by consumer spending. A lot of that is done on credit, as we all know, and a lot of that is being financed through the securitization market. The securitization market, is financing the real world in a very meaningful way. And this aspect of the capital markets is now being disrupted a little bit, I think is fair to say, or certainly it's bringing new questions to one of the fundamental aspects of this capital market security that have not been part of the discussion really since inception.
Yeah, sure. Consumer borrowing stands at about 16 trillion, I think it is, and the capital markets via securitization fund about over three-quarters of that, over 12 trillion. So it's a $12 trillion market that you're messing around with, and as for your moat comment, yes, absolutely, that's critical. You and I know that when we were analyzing deals, we analyzed them by looking all and only at the credit quality of the underlying assets. We did not look at, and so we were able to get rid of, in our thoughts, any possible other legal outcomes. Well, we know actually that there is a standard rating agency method, right, of handling secured credit of an operating company. Typically, they notch off of the unsecured rating of the company, right? So if a company is rated B2, maybe the secured debt of that company is rated B1. So the point is that if you have to have an operating company, if you have to have an operating company as an issuer here, then first you've got to look at what the credit quality of that company is. Now these would be pretty weak weak entities, right? No one is going to say that they are investment grade on standing by themselves. They've got nothing. So they would have low ratings, which means that the highest rating of anything that they issue would be, potentially non-investment grade. So all of the investment grade market would be eliminated. So it is potentially a big thing. It's not that we are predicting that will happen. Somehow or other, it won't. But the point is that the court's reasoning makes that possibility a live one.
Well, we're kind of moving into what I think is an important topic to cover, and that is, what are the implications for securitization? So you've just painted kind of I hope, a worst case scenario of a basically that the market would interpret this legal path as being one that can be easily pursued and maybe often pursued, and it would really destroy the economics of securitization as we know it. That clearly has not happened yet, but it hasn't happened. What strikes me is that this decision was on a narrow case with where the facts of that narrow case are important. You have alleged malfeasance of a servicer or subservicers that created a liability that may now, if you pursued damages against that subservicer with this decision, now you might be able to pursue damages against the trust and the trust assets, therefore eroding then the very securities, the very collateral that is backing the securitized debt. Okay, so that's what's at stake, at least for this case, which you can then extrapolate to other similar securitizations in which the CFPB has jurisdiction to pursue a similar claim. And you might expect that to happen if and when, for example, the servicers are falling down again, are not performing as they are required to perform pursuant to whatever governing documents that they're a party to, right? So when, again, thinking out loud here a little bit, under what circumstances would that type of legal pursuit by the CFPB be more likely to happen? And you can imagine, well, one condition would be that you have a weak servicer, right? So it's more likely that a weak servicer is going to fall down on the job than a very strong, deep-pocketed servicer, or an inexperienced weak servicer would be another. And there, on a relative scale, there are plenty of those in the universe of securitization. So that's one ingredient. And the other ingredient that I would argue is you might be more likely to see, call it you might be more likely to see things go wrong in a securitization if you have relatively weak collateral, right? Things tend to go south more frequently when you have a securitization backed by very, call it subprime assets. Look, in the scheme of things, there are plenty of trusts that perform just fine with subprime assets. I don't mean to paint that with too broad a brush, but probabilistically speaking, it's more likely that things are going to go wrong from a performance perspective when the assets backing your securities are subprime. And so those two ingredients, subprime assets, right, and weak servicers, often go together. But those two ingredients make it more likely that you're going to be chasing, or the CFPB might be chasing a servicer for falling down on the job in the name of protecting consumers. I probably missed some other things, but maybe have you thought about that? Maybe the circumstances under which it's more like that we're likely to see a broadening of this type of pursuit, legal pursuit on the part of the CFPB.
Oh, I think you're exactly right about that, and I would say it is partly because, or maybe even largely because, when when you have performing loans, there's not a whole lot that the servicer really has to do. You know, it just has to accept a payment and update things and handle phone calls, and so on. There's no real problematic interchanges between or exchanges between them. It's when the borrower goes into default and then demands are being made and there's negotiation back and forth and so on, then you have the possibility of people having different incentives and so on, and then the possibility of the consumer saying, hey, they were bullies and they were pushing me around.
Right.
So I think you're right that the risk is higher for subprime deals generally than for prime deals.
And other implications to securitization that I can think of, what's, for example, the trustee's role in these situations? What are they going to do? So I don't know if you given that much thought, Steve. I see it as, well, the trustee who is charged with essentially defending the trust and the trust assets. First of all, let me take a step back. The trustee does very little when things are going as planned. The trustee does very, very little, and is frankly paid very, very little in the course of these transactions. But if something goes wrong in the transaction and they are called to defend it legally, they're going to have to find a way to pay, for example, lawyers to defend the trust and the trust assets against a lawsuit like this one. And if they're going to do that, what they might do is they might do a couple of things. One is they might ask for more money up front. So that's an expense, an incremental expense to the cost of securitization on the front end. The other thing they might do is they might trap cash that would otherwise have gone to investors, securitized investors, and hold that in escrow to ensure that they can pay themselves whatever legal fees are going to come due in defending the trust and the trust assets. And that would be extremely disruptive to, again, the normal course of securitization and what investors expect. Am I getting that right, or am I missing anything in that kind of a formulation?
Yeah, well, I mean, trustees are already entitled to be reimbursed for any expenditures that they make.
Right.
So if they need to hire lawyers to defend the trust, they will just take money out of the waterfall at the top to pay the lawyers. They are also it's a bit more vague usually, but they're also able to collect some money to make sure that they are always that they never are out of pocket. Okay, it's possible going forward that people might even have might set up a reserve account in deals, right?
Mm-hmm.
A reserve account for contingencies where the trust is sued, but for one thing or another. That is possible. It would make the deal much less efficient, right? It would just tie up a bunch of capital and so on. It would be just a muddying of the water, and any muddying of the water is going to ultimately be paid for in the form of higher borrowing costs by borrowers.
Right. So you said the trustee already has an explicit right to reimburse itself, but it might if it felt that the probability, if a trustee felt that the probability of needing to expend serious money on a legal defense, they might preemptively escrow some monies, and so it wouldn't be to reimburse itself, in other words, right? So that's another, and we've seen this happen before, I think, in some very rare cases, thankfully, but the trustee has cordoned off monies at the top of the waterfall in rare circumstances where they are going to be called in to defend a trust.
Right. So it is. I think the what might cause some real anxiety is parties thinking to themselves, hey, wait a second, somebody somewhere is going to have to make some decisions here. Well, that decision making is now very nicely parceled out amongst trustee, servicer, and so on and so on and so on. The trustee does not think of itself as a principal in the deal. They think of themselves as a service provider. They do a few things, and that's it. Now, if they have to make real decisions about how to do things, decisions that will have legal consequences, which will increase the liability of the trust, over which things might, lawsuits might happen, and so on, then they are going to ask for a good bit more money, for sure. And the same thing goes for servicers. Anybody who's potentially going to be subject to liability of this sort is going to ask for more money, and again, that comes out ultimately in higher borrowing costs.
Yeah, I mean, what we're painting a picture here of, I think the sum and substance is that this decision creates a risk. You market participant can ascribe your own probability now to this new risk that your assets may not be worth as much as you thought they were. And this goes not only to investors, but also third parties. We just mentioned the trustee and the servicers. These are all bottom line going to add to the cost of securitization, which is interesting because that's ultimately bad for consumers, which I think it brings about a kind of an ironic, outcome if you keep following this logical path to what the CFPB's mandate is, right? They're there
they're supposed to be strengthening and helping the consumer financial market, and here they may be shooting themselves in the foot.
Right. I mean, I don't think it's too tortured of a path. I think it's a very linear path to get from the implications of this decision to a higher cost of securitizing, to a higher cost of running a finance company or financing a consumer book, and therefore those costs are not going to stop there. They're going to go right to the cost of the cost of borrowing, to consumer costs.
Sure.
And another reaction certainly could be that there's I don't know how to exactly term this, but a flight to quality, in the sense that you only the parties that are going to continue to be able to execute economically or as economically, given this new risk, are going to be those that are the strongest, right? The ones that have, as we were discussing earlier, a very remote possibility, an extremely remote possibility of ever being under the circumstances and where their servicing is called into question or their asset performance is going to go so far south as to cause problems. So only the top of the top then can access this market at what are today fairly economical, advance rates. So, these are real world implications to the decision that run counter, I think, to the CFPB's stated mandate, which again I think is a bit of an ironic outcome of this decision. I haven't
Yeah.
heard a good kind of counter to that, by the way. Have you?
No, I have not. And in fact, what's discouraging is that although the Structured Finance Association, and others filed briefs on behalf of the trusts, the arguments they made are not addressed at all by the Third Circuit or by the District Court. So it's as though they might as well not have spoken,
Yeah.
And so no, it is not the case that this opinion looks at the arguments and says no, they are wrong because blah blah. It just ignores the arguments. So, technically, yes, this is only applicable in the Third Circuit. Technically, the point at issue is whether these issuers are covered persons. So, and everything after that is, in a sense, is what lawyers call dictum. Okay, so even the idea, or well, yeah, maybe, who knows? Maybe the question is, what about this? The judgment that. The determination that the issuers are engaged in the business of consumer finance, that is actually parsing out the definition of covered persons. Well, that's technically might technically be called dictum, but it's pretty thin dictum, and the difficulty is that the Third Circuit did not tie its decision about engaged in the business of consumer finance to anything in the CFPA. Which means that other courts cannot see it as, okay, I can limit this decision to just CFPA stuff, that opens up a huge collection of other problems. So, for example, suppose the Pennsylvania Department of Consumer Affairs, whatever it is, decides to sue these trusts. And it says, hey, the Third Circuit says you're in the business of doing consumer finance, but you haven't registered, you're not licensed, you don't have insurance, you haven't complied with a whole bunch of things, and no one would deny that, right? So, and you've been out of compliance now for 18 years or whatever it is, 15 years. So you owe us a huge range of penalties, and so on and so on and so on. Every single state could potentially do that, or certainly at least the 3 states here could potentially do that. And there are any number of other nasty potential legal consequences if trusts were held to be in the business of consumer finance.
I mean, what have you seen? I spoke at a conference about 2 months ago, and among other things that I talked about in my presentation, I did mention this court case being decided, and then it was a little bit fresher in the news. Arguably, people didn't have a chance to really digest its implications yet. But now, we're almost 3 months, 2.5 months since the decision. I'm kind of surprised that there hasn't been, at least by my observation, more of a kind of headline moment for the industry. It's I want to say it's a hair on fire moment for those of us who kind of know and love securitization as it's been practiced for so many decades now. But I haven't seen that kind of reaction. I wrote an article about it back on the day after the decision, a brief one talking about, what the implications might be. Then there have been maybe a few articles, particularly from law firms, that outline, what the implications could be, but certainly haven't seen any strong reaction that is obvious in the securitization deal flow or anything like that. What have you noticed or seen from your perspective, Steve?
Yeah, I'm surprised also that there hasn't been more heartburn Uh, I think it is because people think to themselves, well, we are just too big to fail.
Mm.
So these nasty outcomes cannot happen. Well, certainly they somehow or other will not happen. The only question is what will prevent them. And our concern is that nothing in the court's opinion prevents them necessarily. So I've been surprised about it, but it should be noticed that legal consequences are not the sort of thing that necessarily happen in 2 months, 3
Right.
months. Yeah,
Right.
it could be 2 years, 3 years, 5 years, whatever, and then people start really exploiting the openness of the reasoning in this court's opinion.
Is there anything that trusts or servicers can do now to mitigate this new risk in your mind?
Well, you mentioned articles by law firms. There have been several in which law firms have said, well, you might try doing this, that, or the other thing. None of those are all perfectly good things to do, for sure.
Like indemnification, maybe, which is probably already there, right?
Yeah, right. Well, first of all, taking words like engaged in out of your formation documents, that sort of thing, which that sort of thing. Maybe if you are a service, maybe if you have a lot of defaulted receivables, you just decide not to file any collections lawsuits, that sort of thing. So there are things that you can do to try to mitigate the chances that somebody comes after you, and that will, as a practical matter, probably keep you safe, but it doesn't necessarily keep you safe.
Right, and you know that's the so you can edit certain for that. And by the way, that only really is going to help you on a go forward basis. We have, you know, as you said, trillions of dollars worth of securities that have whatever language they have, and I doubt very much that anyone is going to go open those documents back up because of this case and edit them, and the amount of expense involved wouldn't make that economical, and the administration involved. So that would only work on a go forward basis. And by the way, who's to say that that's a mitigant? It is not a bulletproof strategy by any means, because you're talking about form over substance to a large degree, both with respect to redacting language like, as you said, engaged in, which is already, as you made the point, this is a form over substance argument. They're not engaged in, certainly not directly engaged in. Number one. And number two, I mean, the indemnification language is, I'm pretty sure, is there already. Services are indemnifying against these types of damages. The question is, how deep are their pockets? How much value is there in any indemnification clauses, not just for servicers, for any entity, right? So these are, something that the market is used to looking at.
The language is there. And it does, but it is not really drawn on very much at all. So potentially you would have some nasty cases where the servicer and the trustee and other people are fighting each other and the deal about who has to ultimately pay for this, that, or the other thing. Well, the deal has no resources other than its assets, and those assets are supposed to be going to the bondholders. So this is going to take money away from them that no one anticipated that this sort of thing was in the cards. The deals were not structured to handle this sort of risk, and who knows what happens.
So, Steve, I referenced this earlier, but maybe you can fill in some of the blanks. We've had 2.5 months since the March 19th decision. What has occurred since then that's related to this? Anything of consequence that our listeners should be aware of?
Well, after that decision came down, the parties went to the district court judge and said, please hold off on doing anything further, because we are engaged in negotiations about a possible settlement. And also the defendant trusts, filed for en banc review in the Third Circuit. That is the Third Circuit is like any other circuit. It has a lot of judges, I don't know, 30, 40, whatever it is, judges. And for any particular case, is a panel of 3 who are assigned to hear that case went on appeal. If people think, hey, this is a crazy decision, you can ask for en banc review, and that is the entire 30 or 40 judges, whoever they are, sit down and hear and essentially retry the case. So that has been requested, but it is by no means a right of the defendants, so it's not at all clear what's going to happen there.
Do you have any sense of how often en banc path is used at this court level?
It's not common. It's not common and cannot be common,
right.
because the efficient administration of justice just cannot handle all 30 or 40 judges sitting down and focusing on one case. That's just not an economical way of using your appeals court judges. So it's not a common thing at all.
And you really have to make the case. No pun intended. You have to make the case for an en banc review to be accepted, that the decision by the 3 original judges was flawed in some. I think you have to make a very convincing case that it was flawed in a material way or with material implications.
Well, you have to do more than that. You have to make the case that, first of all, this is terrible public policy. So it's wrong on the policy front and terrible for consumers. Then you also have to make the case that it is terrible as a legal decision. Just the court's reasoning, is not going to win any awards. That's for damn sure. Except for a Darwin Award, maybe, for shooting themselves in the foot. I don't know, but it's not. It's really not good, and frankly, if I were a Third Circuit judge looking at that, I'd be embarrassed. I'd think, wait a second, we can do better than this. Come on,
right.
And so I think there's a very strong argument for en banc review. This is not about $2.5 million and a couple of trusts. This is about something much larger, and so it's kind of and you might think that the Third Circuit would like to get that right, so I think that there's certainly a possibility. I have no idea what they will do though.
And this is already been requested, as you said. And has a request been made? Is it typical you go en banc, and then if for some reason that isn't accepted, then your next path would be Supreme Court?
Well, you often leave out en banc because you don't really. You might have no reasonable expectation that anybody else in this circuit is going to be on your side.
Okay.
And so, people then file for Supreme Court review. People file en banc requests all the time, and they just routinely get denied. Just as people file for Supreme Court review all the time, and they routinely get denied. But I would expect mostly people go straight from the circuit court to the Supreme Court, and the Supreme Court says, no, we're not going to look at it, and that's the end of the matter.
Okay, so the fact that they've whoever. I guess the lawyers for the NCLST have decided to pursue the en banc path here suggests that they, like you, I guess, are thinking they have a good shot at good shot at getting that en banc review accepted.
Yeah, I think so. Although there's a potentially troubling uh, uh, difference of interest here.
Mm.
That is, if the trusts think to themselves, maybe we can settle with the CFPB, pay them $1 million or $2,
Hmm.
and that's less than the cost of our lawyers for these appeals and all this other kind of stuff. That's a rational thing to do.
Sure.
The problem
And it
is
leaves
that
us out there.
then there is this law out there
Yeah.
which is nasty law. So the industry certainly would like them to continue with the appeals process, and frankly, the industry probably ought to finance some of that appeals process. I have no idea how that's being handled. But trusts themselves, as we said, don't have any assets to be doing this sort of thing, since this is really an industry problem. The industry ought to be taking the lead in handling it.
Right. And while we're on the topic of, I guess legal paths or hopefully solutions to this problem as we see it, as we've defined it, what are there any other paths maybe outside of the legal realm that you can think of that might
Well,
mitigate or
the simplest, of course, is for Congress to
Mhm.
say no. Securitization vehicles are not covered persons. The thing is, this is not a constitutional question. This is a question in which the Third Circuit, and before it the District Court, was interpreting a federal statute. So the maker of that federal statute, Congress, can come back and say, no, that's not what we meant, and and the decision is vacated, right? Well, that would be the best thing to happen. But, Congress is a fractious bunch of people. These are really, really controversial political things. And so you can see that not too many people may be interested in sticking their necks out. And so they may just hope that the courts handle it for them.
Right. So, yeah, legislation could come in, but that's a very low odds path, I guess, is what you're saying. That made sense.
Mm-hmm.
I mean, the CFPB has certainly been a lightning rod from a political perspective since it was conceived of, let alone put in
And there have
practice.
it has already been up in front of the Supreme Court twice.
Right.
The Supreme Court in the first case said, no, the way in which your leader is potentially fireable is unconstitutional. It has to be at the discretion of the president, not because it had been that you could only get them out of there if they were, I don't know, grossly negligent or something like that. So the Supreme Court said, no, that's not constitutional, and it chopped that part out of the statute. Recently, they were back in front of the Supreme Court arguing about the way in which the CFPB is financed, and there the court held that the financing mechanism is constitutional. So
Right.
there's a lot of fighting going on over an awful lot of things having to do with the CFPB.
Right. Okay. Well, that's, again, I want to make sure we covered everything that I think we have. Like I said, we've gone into a lot of detail here. I suspect we're going to have a part 2 on this topic as the case unfolds, as the request for en banc unfolds, as the specific case. Now it's either pursued either by virtue of a settlement, as you said, I guess there are settlement negotiations underway, which I guess could be breaking news any day now, or it could maybe they won't reach a settlement, and it gets go back down to the lower courts to get set to follow that legal path, right? Which could take It's already taken years. It could take years more, I suppose, right?
Oh yeah, this litigation dates from 2017, so it's gone up and down and back and forth and so on. But yes, if they do not settle it, and if there is not en banc review, then they go back to the district court and litigate the question of whether or not the trust ought to be liable for these activities.
Right.
So.
Okay. Well, Steve, thank you. First of all, really quite an education for me, and I'm certain for our listeners as well. We'll be following this court case very, very closely, and this issue. I shouldn't say just this court case. This issue very, very closely. I'm certainly would welcome any feedback we get from listeners about how they're seeing this case, if it's on their radar screen, or even if it's not on their radar screen now, it would be if they've listened to this, if they've listened to the podcast this far, and what they think of it, because as I think you and I agree, this has some pretty serious and weighty implications for securitization as we know it. So, Steve, thank you again for illuminating all of us. Appreciate it.
Thanks for having me, Will.
Okay. Bye, everyone.
Bye.